We as leaders shall lead our country on the path of peace and shall find solutions for issues and problems facing us. Grant us the mercy, O Lord, that we shall today also honor thy name in all we do, think, and say. Almighty God, we pray thee, bless our land and all its people. This all we pray in the name of Jesus Christ our Lord. Amen. I solemnly affirm that I will be faithful to the Republic of Namibia and its people, and I solemnly promise to uphold and defend the Constitution and the laws of the Republic of Namibia to the best of my ability. Thank you. Session is called to order. Thank you very much, honorable members. In guidance of what the members say, I just want to announce that the Parliament has received secondment of 2 legal officers. One is Ms. Hilma, and the other one is Ms. Chusom Obidio. Help me with, who's the Chief Legal Officer from the Ministry of Justice. Yeah. Welcome, thank you very much. I just wanted to notify so that tomorrow when she sits here, you must not ask who's this new person, isn't it? We are sometimes hostile to visitors, so now you know tomorrow. Come again? We are at announcements, we will come. Thank you very much. Any petitions? Any reports of standing committee? Other reports and papers? I will always grant you, you know, Musam. All other reports and papers, or today you omit? Okay. Notices of questions? Oh, sorry. Notices, other reports and papers? Okay. I'm just used to one direction when it comes to this topic.
Thank you very much. Honorable Speaker, honorable members, very good afternoon. I lay upon the table in terms of Rule 222 of the Standing Rules and Orders, reports of the Auditor General on the accounts of the Namibian Competition Commission for the financial year ended 31st March 2025, and Film and Video Development Fund of the Namibian Film Commission for the financial year ended 31st March 2024. I so move, Honorable Speaker.
Thank you. Please table the report. Thank you very much. Maybe just to hijack the flow here. Honorable members, you will take note that the blue paper, the order paper, is not there. We have got a problem with the printers, but I implored on the staff to assist the members to log in using the advanced technology. If you have got a challenge, I think they will be around just to assist. But there is a simple procedure of just logging in, and we can follow the order paper online. This is, yeah. Yeah, it's for people like Honorable Karondo and so who are technological challenged. Okay. Yeah, please assist there. Just to switch on, start with switching on. Okay. I've got notices of questions. I see Honorable Ambrosius Kumba.
Thank you, Honorable Deputy Speaker. I hereby give notice that on Thursday, 9th of October 2025, I shall ask the Minister of Information, Communication and Technology, Honorable Emma Theophilus, the following question. NBC vision is to become the leading multimedia broadcaster of choice in Africa, and especially in Namibia in particular. But this does not seem to be the case at the moment. My questions are as follows. Why is NBC at times selective in covering national and regional events of different political parties after they have requested coverage? 2, NBC has an office in Kurenkuru, 135 kilometers west of Divundu in Kavango West, which is commendable. But why not also in Divundu, 200 kilometers east of Rundu in Kavango East? Can the minister consider setting up a permanent office in Divundu, as it is a growth point too? 3, the current population coverage stands at 74.5%. Now, when will NBC reach 100% coverage after more than 3.5 decades, Honorable Minister? I so submit.
Thank you.
Honorable Speaker, I have 2 questions.
Just like yesterday, just come, submit and go. You printed twice, you can walk twice also.
Can I table?
Table the first one. Thank you, Secretary. Thank you.
Once more, thank you, Honorable Deputy Speaker, for my second question. I hereby give notice that on Thursday, the same day, 9th of October 2025, I shall ask the Minister of Works and Transport, Honorable Veiko Nekundu, the following questions. Honorable Speaker, honorable members, the Bagani and Omega airstrips were constructed in 1970s and 1980s, before independence. The purpose was to cater for colonial soldiers, logistics within the war zone at that time. Now, Honorable Minister, with due respect, as you were in the ministry and now serve as a fully fledged senior minister, are there any leasehold agreement regarding the airstrips between the ministry and the traditional authority, since the airstrips are in the communal land area under the custodian of the late Fumu Max Makushe, late Fumu Alphonse Mayavero, the late Fumu Dimbare Franz, and the sitting Fumu Erwin Munika Mbambo of the Hambukushu Kingdom. 2, the surrounding lodges in the area close to Mahango and the Bwabata Game Parks are mostly the users of this airstrip. The surrounding lodges in the area close to Mahango and Bwabata Game Park are mostly the users of this airstrip. Now, who controls the landings of aircrafts as they happen day and night at these airstrips? How does government benefit from the airstrips, and how does the immediate community benefit from these airstrips, either directly or indirectly in a tangible way? Here I mean things that they can see, that are these benefits, they can touch, they can feel, and be proud of in the village that was once a war zone in the past. As the custodians of the ministry under which the airstrips fall, there has been no tangible direct benefit to the people so far. What plans are in place to ensure that these people are prioritized, since they are also victims of multidimensional poverty and are becoming post-independence marginalized? Lastly, why are these two airstrips abandoned for decades, especially Bagani airstrip amidst Namibia's blueberries in Divundu, the town close to Bagani? I so submit, Honorable Speaker.
Thank you. Please table the question. Honorable Nashinge.
Thank you very much, Honorable Deputy Speaker. Good afternoon. I hereby give notice that on Thursday, the 2nd of October 2025, I shall be asking the Honorable Minister, in absentia of Home Affairs, Immigration, Safety and Security, the following questions. While services such as name changes, surname changes, and other approvals under Birth, Marriages and Death Registration Act of 1963 can be lodged at regional Home Affairs offices, the final approval is still centralized in Windhoek. This system creates long delays and unnecessary frustration for the public, as documents must be sent to Windhoek before a decision is made. Citizens, especially unemployed persons and students, not only face financial costs, but also extend waiting periods that affect their daily lives. Even officials within the ministry have previously acknowledged this inefficiency, yet no reforms have been implemented. Namibia, 35 years later. I therefore ask Honorable Lucia Ipumbu the following questions once more. One, why are services such as name changes, surname changes, and related approvals still centralized in Windhoek despite the decentralization policy? Two, what steps has the ministry taken or will it take to fully extend these services to regional Home Affairs offices countrywide? By when, number three, by when can the public expect a clear plan to make these services accessible in all regions? Fourth and final, Honorable Minister, why is Namibia, after 35 years of independence and self-rule, still governed by the colonial era Birth, Death, and Marriage Registration Act 81 of 1963 of the then South Africa of apartheid, a law written for Southwest Africa? When will this outdated piece of legislation be repealed and replaced with a modern law that reflects the realities and dignity of an independent Namibia? I so submit.
Thank you. Please table the question. I now recognize Honorable Mulunga.
Thank you very much, Deputy Speaker. I hereby give notice that on Thursday, 2nd of October, 2025, I shall ask the Honorable Minister, Dr. Inge Zamwani Kamwi, the following questions. Honorable Minister, it is alleged that 6.2 million was defrauded from the AMTA accounts. Yet instead of resolving the matter transparently, AMTA board has spent about 10 million of public funds on lawyers, supposedly to investigate the missing money and conduct disciplinary hearings, which by reports were not even carried out procedurally. These actions raise serious questions about accountability and the proper use of taxpayers' money at AMTA. I therefore like to ask the following questions. can you provide this House with the proof that the 6.2 million is indeed missing from AMTA's accounts? Number two, 2 individuals were dismissed in relation to this case. Is this dismissal alone considered sufficient, or was a criminal case formally opened against them? And what is the case number? Number 3, how does your ministry justify the AMTA board spending over 10 million on lawyers for investigations and disciplinary processes that were allegedly done non-procedurally? Finally, what immediate actions will your ministry take to hold the AMTA board accountable for the wasteful and questionable decisions I so submit? Thank you. Honorable Speaker.
Honorable Ngombe.
Thank you, Honorable Deputy Speaker. I hereby give notice that on the 9th of October 2025, I shall ask the Minister of Industry, Mines and Energy, Honorable Natangwe Ithete, the following. Honorable Deputy Speaker, recognizing that the Ministry of Industry, Mines and Energy plays a pivotal role in facilitating economic growth, job creation, and sustainable development through its regulations of industry, mines, and energy sector. What is the current number of exclusive prospecting license applications and mining claims that are pending for more than 12 months, and what is being done to reduce such backlog? What internal capacity challenges are being faced by the Ministry of Industry, Mines and Energy that contribute to delays in processing license applications? How many mining or exploration licenses issued by Ministry of Industry, Mines and Energy are currently inactive? What legal or administrative measures has Ministry of Industry, Mines and Energy taken or plans to take against holders of inactive licenses to ensure lands or mineral rights are not tied up unnecessarily? I so submit.
Thank you. Please take over. Honorable Likando Rodri. Oh, so. I thought it.
Huh? Thank you very much, Honorable Deputy Speaker. I hereby give notice that on Thursday, the 9th of October 2025, I shall ask the Honorable Minister of Environment, Forest and Tourism the following questions. Honorable Speaker, Namibia just witnessed one of the worst environmental disasters in our history. A wildfire inside Etosha National Park burned and destroyed grazing areas for wildlife, threatening endangered species and putting at risk the tourism industry that sustains thousands of jobs. Despite this, Namibia still operates without a finalized national fire management strategy, and firefighting resources are inadequate. I therefore wish to pose the following questions to the Honorable Minister. Can the Honorable Minister confirm for the record the total number of hectares destroyed in the Etosha National Park wildfire, and specify the damage to wildlife, grazing areas and tourism facilities? Why did the government rely so heavily on Namibian Defense Forces, personnel services, police personnel services, conservancy rangers and local volunteers instead of having a dedicated national wildfire unit? What immediate steps is the ministry taking to restore wildlife habitats and grazing areas destroyed in Etosha? And what relief
is being provided to surrounding communities who lost grazing land and livelihood?
Reassign.
Why did the ministry only deploy significant firefighting resources days after the fire started, by which time nearly 38% of Etosha has already burned? Can the minister explain what firefighting training, if any, our military and police personnel have to effectively combat wildfires?
Tell us.
Why did the ministry not request assistance from private firefighting companies, despite their proven capacity and expertise, which could have significantly reduced the scale of destruction? Will the minister commit to establishing an emergency wildfire relief fund? And if not, how will affected farmers, community and conservancies be compensated? Honorable Speaker, I so submit.
Thank you, Mr. Honorable Bakera.
I hereby give notice that on the 9th of October 2025, I shall ask the Minister of Urban and Rural Development, Honorable Sangwaza James Sangwaza, the following. Honorable Minister, the Ministry of Urban and Rural Development embarked on a significant project to reorganize local authorities at the municipality part 2, town and village council levels. The challenges faced by these local authorities included personnel placement, lack of adequately trained staff, and need for organizational restructuring, and as a result, such prompted a comprehensive study. Countrywide stakeholder consultations were done, and it led to a recommendation to form a task team in 2014. The task team completed their work in 2016. However, due to delays in implementation of the recommendations by the task team, a new task team was assembled in 2023. The objective of the new task team were comprehensive and aimed at addressing the shortcomings of previous 2014 exercise. These objectives included developing universal organizational structures, reviewing and developing job profiles, evaluating and grading of all positions, and developing a market-related standardized wage structures in the municipalities. The team included experts from different municipalities, human resource managers, and representatives of Namibia Public Workers Union. The team also aimed to make recommendations for future local authorities. This task team held several workshops and completed various activities from August 2023 to November 2023. The key achievements included the revision of organizational structures for 54 local authorities, the creation of new positions, and the development of standardized remuneration and wage structures. Critical positions omitted in the previous exercise were also created, and job descriptions for all positions were reviewed and developed. The team proposed further recommendations, including changes in local authority statuses, and prepared a program for report presentation to the ministry. Hence, the report was presented February 2025 to the Ministry of Urban and Rural Development. Therefore, I would like to ask the Honorable Minister whether the Honorable Minister is aware of the task team's report of 7 February 2025, and if the Minister is aware, when will the Honorable Minister pronounce the Ministry's position on the report? I so submit, Honorable Speaker. Thank you.
Thank you. Please table the question. Thank you. Thank you. Honorable Lucato. Please, Honorable Lucato is waiting for you, honorable members.
Honorable Deputy Speaker, members of Parliament,
all political leaders,
and the leaders of all political parties, and good day.
Thank you.
And Dumela. Okay. I hereby give notes that on Thursday, 9 October 2025, I shall ask the following question to the Minister of Urban and Rural Development, Honorable James Sankwasa, my relative brother, who is a very active minister, the following regarding the increased tax rates at Osona near Okahanja, which is situated under the municipality. So, Honorable Minister, it was alleged that the rates and the taxes increased twice this year at Osona village, which is near Okahanja in the Ochizonduva region. Honorable Minister, can you please look into this matter and come up with a solution and respond, as the community of Osona village are crying in this regard. Honorable Speaker, I so submit.
Yes. Thank you. Please table the question. Thank you. Honorable Motu. Honorable Sumaip, I thought...
Deputy Speaker, mine is an urgent all
Okay.
questions.
Let's dispose of all written questions. Are they all done? Oh, Honorable Yemba.
Thank you, Honorable Deputy Speaker. I hereby give notice that on Thursday, the 9th of October 2025, I shall ask the Honorable Minister of Home Affairs, Immigration, Safety and Security, Honorable Lucia Ipumbu, the following questions. Honorable Speaker, honorable members, the men and women serving as immigration and police officers at our borders are the hope of safety and security for the Namibian people. And I am sure you will agree with me that not a single Namibian would like this hope to die. Yet they are forced to endure deplorable conditions. We have taken note with consent that the new office building at North Hoover has a serious crack posing danger to the officials, and in addition, these officers are left with no choice but to consume water from open rivers, subjecting them to waterborne diseases and other health risks. And this is not limited to this particular area, but countrywide. This neglect is unacceptable. As front runners and defenders of our lives and properties, they deserve better. The officers are the backbone of our security and safety, and to subject them to such a deplorable condition is nothing short of betrayal of our collective responsibility to the people who have committed themselves to protect us with their lives, and it is a callous disregard. Therefore, I ask the following question. One, what immediate steps will the minister or the ministry take to provide potable water to officers at Verloor Drift and North Hoover who are currently drinking unfiltered river water and so on? And number two, what actions is the ministry taking regarding the serious structural crack in the new building of North Hoover? I so submit, Honorable Speaker.
Thank you. Please table the questions. Any other written question? Okay, I think we'll revert back to Honorable Motu.
Thank you very much, Honorable Deputy Speaker. Honorable Deputy Speaker, my question is to the Minister of Health, but due to her absence, I would like to then refer the question to the Prime Minister, who is the head of the Public Service Commissioner, if you may allow me. Honorable Minister, Right Honorable Prime Minister, I'm not sure if you are aware of this, but currently in Marintal there's a standstill because there has been tribal procedures in terms of the interviews being conducted at the Nursing Institute to hire personnel under the Health Ministry. Now, there has been a leakage, firstly, of information in terms of the interview test that the students had to go through. The first being that the test was leaked on a WhatsApp group that is predominantly opened by members of the northern areas, northern regions. And this test information stands as follows. Number one, please share the interview questions of the Marintal people. The interview questions are as following. Number one, nursing process. Number two, ethical principle. Number three, stages of labor. Number four, immunization schedule. Number five, the baseline test for ANC. Mention and explain all of this, 25 marks. This was the test. And all the members, 50-something members who actually went to the second phase of the interview, which is the oral phase, had this information at their disposal, excluding, number one, the people from the southern area in Marintal, who have been excluded also from the interviews, who have failed to proceed to the oral questions. Now, my question is, Honorable Minister, under the capable leadership of the Hartap Regional Council, governed by the capable Landless People's Movement, has passed a resolution that was aimed to addressing local unemployment within the Marintal area in Hartap, but Marintal specifically, that states that the natives should be given top priority in terms of the employment processes. Now, all the natives have been excluded, they have failed, they have not gone through to the second process. All the other interviewees are northerners. Why are we continuing to ensure that we go against our constitutional right and perpetrating tribalism within the interviewing processes, Honorable Minister? Number two, if you are aware of this situation, we have tried to stall the interview processes from proceeding, but then they have stopped it, but they continued because they do not. I would like the full attention of the Minister, please. This is very important. My Honorable Minister. And secondly, we have tried to stop. Currently, there is a demonstration being held outside the facility, and they informed us that they will not stop. In fact, there are allegations of a top official that stated that they will not employ Nama-speaking people because they are drunkards. And this was said publicly.
That's sad.
Honorable Right Prime Minister, and this is tribalism. So what are you going to do with this process? Can you please stop the interviewing until the investigation on who leaked this information comes out, and then you start the process again?
Do you have an answer?
Thank you very much, Honorable Motu. Thank you very much for the question. I think as a principle, let's all be agreed that tribalism and all other isms that are counterproductive to building a nation and our own pathway of nation building, we condemn tribalism wherever it rears its head. And we must do that both in terms of addressing it as members of parliament, but also saying so, both your side and our side, we condemn it. So we are united on that particular point. Now, specific to your question, the Honorable Governor of Hardap, I think if not yet, I think he's addressing that matter. And well, take it from me. The Minister also has been alerted precisely on the issues that you are saying. I think the regional leadership, and I'm sure they will consult the chairperson, because we are aware of what you have said. So they are addressing it in a matter of maybe a few minutes. If not, you precisely hear what has been decided. Suffice it to say, we must, in the strongest term, condemn whenever those acts of tribalism is happening. Two, it is understood that there are some that are making certain statements which are provocative, one, insulting, etc. That should not have a place, especially in the public service. When you are interviewing or you are conducting a process, let it be as transparent as possible. But also, we should not do so blind by factors as we know them. Yesterday, the Deputy Prime Minister raised a point in terms of how we must implement laws. Now, there are some laws, for example, that says that in a bakkie you can only be 2 occupants in terms of law. Now, if you are a traffic officer and you are found maybe somewhere putting up a roadblock and say that you are going to legislate no bakkie must pass that has more than 2 people. Now, imagine a situation where you are sitting on a road where mourners are in the car, where weddings are passing. Sometimes you must know that common sense here dictates that, yes, there is this, but sometimes common sense must say this is wrong. So hence, if you follow certain things in a certain particular place where you are, and you want to say that I will follow it blindly, the law says X, Y, Z, you are likely to discriminate or leave out certain people and harm or hurt certain people. And I think in the fullness of time, this matter will be spoken to by the governor as well as the line minister. But suffice it to say, Honorable Motu, it is something that we must all condemn, not only because it is in Hardap, but it must be condemned anyway. If it is happening in the east, the west, the south, the north, anywhere where that is happening, we must condemn it. We must condemn it wherever it is. So that is how nations are built, is when we are able to say competency must be, but also competency not discriminating others when you know that they too possess the qualification. I think in this case, Honorable Deputy Speaker, like I said, it's just a matter of minutes. You will see from the governor. You will see. Yeah, I like it. You see, he say, I like the honorable.
No,
I like the honorable member.
I think you have answered the question. So the comma, it's fine, PM. You have answered the question. I think.
Yeah, no, it's okay. It's understood. We are together on this point. Very soon, and I like it. Honorable Swatboy is excited.
Okay,
yes, thank you very much.
Thank you. My sister, just for you see, we have 20 minutes, we spent 10 minutes. No, who was speaking? Toshitino? No, you see, that discretion is on me, and I'm saying I've got Honorable Amupanda, Hengari, Honorable Swartboy, Honorable Berta, Honorable Somai, Honorable Kampala. In that list, will we make it in 10 minutes? No, I want us to go. So in that view, just put it in writing, but I think the matter has been addressed. Okay. Honorable Ampanda.
Yeah, thank you, Deputy Speaker. I have an urgent oral questions to the Minister responsible for Finance. Relatedly, Prime Minister, congratulations on the Youth Fund. And Minister, you remember we were cautioning you because of the information that we knew about the Youth Fund. And we indicated to you that we agree with the principle and we support, we are the champions of that program. Now, I have 2 specific questions with regards to the Youth Fund on the basis of the information that we just received this morning. Now, we've always had a problem with governors and politicians that are involved in one way or the other in selecting these young people. Now, we raised the concern about the rushed due date, and we thank the government for extending it. And some region extended it to the 4th of September. There is a company that is successful. This is facts, eh? There's a company that is successful, and it was registered on the 18th of September with BIPA. 18th of September. The due date for application is on the 4th of September. How is that company going to be successful when it did not exist, when it wasn't registered on the 4th of September, on the due date of the application? That's one aspect of the problem that they are dealing with. The second aspect, there are successful companies out of that 42, Minister, that some of them are not even registered with BIPA. We took that list, we check it against BIPA to really see whether these people are registered. They are not registered. Yes. They are there on social media displaying the church that they belong to. And one starts actually wondering, did they get to be successful because they belong to a particular church, even when the laws of our country they are not registered? So we wonder actually, Minister. So the government is going to be giving the funds to who when they are not registered with BIPA? That's very, 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 very problematic, and it speaks to the criteria that was used to, and you are saying you must have a company. Yes. Now this person doesn't have a company, and the company is registered on the 18th, maybe what, this is 2 weeks after the due date? How does something like that happen? And it doesn't speak to it doesn't say the program is not good. It doesn't say we are not happy with the program, but we're just cautioning this. Lastly, you now, out of 11,400 something, you now have 11,000 ideas of young people. This program is going to continue. You have 11,000 ideas. The only reason why the 43rd young person did not succeed is not that his idea was not good. It's because the number that was being accommodated is 42. Right? Because they only needed to take 42. So since the program is going to continue, how do we ensure that the intellectual properties, the ideas, the proposals of all these 11,000 young people are not going to end up on the name of the company of Amupanda, who belongs to a particular church and sings well, and therefore the application is going to be successful. So that's a big problem. So we just need clarification on those two things. They're quite very serious. And if we just think people are just playing politics, because we knew these things already, they were already celebrating. So we want to hear. We have other information, but we want to give you an opportunity to address and tell us exactly what is the direction on this matter before we get into other details without accusing anybody. But it's over to you.
Yes, Honorable Minister. No. I think the question is to, oh, you want to take it, PM? Huh? Finance? No, but the PM is the leader of government. You can choose.
Okay, fine.
PM. No, honorable members, Prime Minister is the leader of government business. Just wait. If a question is put to Honorable Kambala, then the leader of AR has got that right to say, I'm taking that responsibility. Then Kambala will comply. So the question is put to the... Where is the inconsistency? The Prime Minister is the leader of government business. Yes. So if he tells his junior, I'm taking the question, there is nothing. Yes. Isn't it? Let us also, okay.
No. The one asking question or asking the question has made it clear to both. That's what he said? He said both. So, and we are both. We are together. Yes, Honorable Ampanda, thank you very much for the question. If the company alleged was registered in future present tense, that's what it is. It is clear that it's irregular unless it is matrix overload and the AI future present tense. Yes, basically, if that company did not exist, and it existed 2 weeks later, there must be a glitch within BIPA. If it is not a glitch, then it's a deliberate, well, there must be something irregular about that. Or maybe, even if it is a name reservation, it's wrong. So there's no way that a company can be registered or a birthday of somebody can be in the future while the birth has taken place later. So that one is a wrong procedural issue. And if it is, and I think after this we can probably again through the line minister, we can get that, because I was there, I launched the fund. And we made it very clear that this fund and the youth empowerment, fortunately all of you, you understand the passion with which this program must be carried out, and we cannot play with it. We cannot play with the dreams and hopes of the young people. We said nobody must misuse it, abuse it, or corruptly somehow find their way into that. So we would want to get that company. We would want to know the application. We will follow that through. As we said, there are DFIs, Agribank, DBN, and EIF, and NAMPOST is coming. So there will be 4. No. Those 4. So in this case, that company must have gone through one of these, and therefore we will follow the footprints where that has happened. And you ask another question about the intellectual property of the companies, in this case around maybe say 12,000. What happens to the next one, or what happens to their ideas? And we made that also very clear, that what happened in Hobabis, that was just a pilot to announce those ones. It does not mean that all the 11,000 or many, many other young Namibians who have ideas, the ideas have been cut short. No. And we also said, fortunately, the total number of the money disbursed was about 14 million. And what is capitalized in terms of that fund for this financial year is 257 million. Yeah, this is just for this financial year. The whole package is 500 million. So it follows that, and I wanted to repeat this again. It follows that in all 14 regions, in all 121 constituencies, the young people must continue to benefit from this fund. And it is not, the political card will not be asked, it will not be said, are you LPM, are you this one? The qualification is a Namibian youth. Yes. The qualification is a Namibian youth. Yes. The qualification is a Namibian youth. And because if that were to be the case, even to suggest it, it will mean that from this side we have no integrity. And if we have zero integrity here, then there is also zero integrity there. Because even some of those who are governors, even those are some of those that are governors, and ourselves here, is the same generation. Is the same generation. No. And we have sang, even the singing of the singing that you are referring to, he sings better when it comes to youth empowerment, youth empowerment, youth empowerment. So we are in this together, including everybody here. So what we want is the 500 million must benefit all Namibian youth. And the 500 million must benefit every corner of Namibia. So that is what we need to do. And Honorable Mpanda, if there is any other information, please share it. Yes, please share it. It must be as transparent as possible. It must be as corruption-free as possible. And if anybody here, including Honorable Motu, if it is found that there is somebody, or you know some other information of somebody coming through to this fund and doing other things, let us know. Let us know. Okay, Onsalke.
Okay.
Thank you very much.
Thank you.
Oh, yeah. Sorry. The age is another issue, and we mentioned this issue. They know these ones. They know that, and West Commonwealth in the Congo. Yeah. So I think this one is public interest. This point is public interest.
Thank you. Let's listen. Public interest.
Yes, this is public interest. It is in respect of the age. Now, some have asked that there's a category of young people or graduates of young people who are excluded. Some are saying, why is it not reaching to 40 instead of just at 35? Some are saying at 45. Now, why I'm saying is public interest, and the people I have mentioned, including Comrade Jerry and others, when we were secretaries of the Youth League, our age group was below 45. So now we are saying, and we said it in Kobabis, that those in the category of 35 to 40, a conversation can be had. So that if, for example, this person is running a profitable business or has accumulated expertise in this field of business, after all, we are saying we want to mentor this new entrance into the business space. So we cannot and should not exclude them from at least providing that service, 1, 2. And if they are able to apply through these 3 DFIs, they should also not be excluded. And finally, through the Honorable Minister of Education, today in Grootfontein, the youth are also receiving some additional support through NYC. So as you can see, Honorable Deputy Speaker, Honorable Deputy Speaker,
let us.
Yes, youth credit scheme. So we are ensuring that now, honorable members, as you know, NYC is made up of affiliates, and those affiliates are not only this side. Some are church groups, some are political parties that are that side. So it is inclusive. Thank you very much, Honorable Deputy Speaker.
Thank you. Okay. I think maybe. Yeah, no, I think you can bring it in. Yeah, we've exhausted the 20 minutes. I just want to follow. No, but you see, no, you see, let us, the questions are yours, the answers are yours. And it says time allowed for urgent questions must not exceed 20 minutes each day. As a blifto, it must not exceed 20 minutes each day. We'll have, the discretion is there, but the rule says the time allowed for urgent question must not exceed 20 minutes each day. My lawyer, learned friend. You see, it's the same day. We'll have another round. The questions are important, like that one. Maybe it's a conversation to say, how do we package? And if you allow me just to say in terms of the rule, the limitations I have, I really want everybody. But I'm saying it cannot. Let's read. Enna, where is my learned friend, Lizazi? You're always on point. Why are you not helping me today? Thank you. But the rules are saying 20 minutes. We have done justice. And I know it's a topic. Another day is coming. Notices of motions? Motions? Okay. No. Oh, motion. Motion.
On a point of privilege of yesterday. Yesterday you said I should look for the...
Honorable members, on a point of privilege of yesterday,
you said,
okay, no, you see, no, the one of yesterday is and maybe we can entertain the new one. All I ask is sit down, honorable member. I asked you yesterday, quote the rule of privilege.
Yeah, here's
Now
the
you
rule
quote it, but
Yeah.
the bus has left the station. As
No,
they said.
no, you said till I get it.
No,
Yes.
no, don't. We can go back to the answer.
Yeah.
Not till not till you
Go
get
back
it.
to the answer, yes.
No, I think that one of yesterday we can reverse. Will use? Yeah. Honorable Lukato, notice of motion.
Sorry. Yeah, okay. Honorable Deputy Speaker, members of Parliament, can honorable members, okay. Thank you very much for the platform, Honorable Deputy Speaker. I hereby give notice that on Wednesday, 8 October 2025, is regarding the issue of ending a one-party system of government in the world. I shall move, Honorable Speaker, I rise to move that this August House debates and considers the implications surrounding the continued role of countries around the world whose systems of government are one-party system, which...
Thank you, honorable members, please. Please, respect the member.
Around the world, those systems of government are one-party state, which territories around Tehran and the absence of the democratic process, Namibia is signatory to both the United Nations Charter and the African Union. In both documents are salient rules and policies which dictate the operations of these bodies. By attaching and appending signatories to these documents, an indication that the nation should implement the tenets contained therein. Namibia is a democratic, cannot attain a situation in which other nations keep on deliberately violating the rules assured in the documents. Honorable Speaker, honorable members, I therefore move that this matter be referred to the Parliamentary Standing Committee on International Relations, and the trade and security for inquiry, and that report be tabled before this House in due course. Honorable Speaker, I so move.
Thank you very much. Please table your motion. Thank you. I think we've got 2 minutes to tea break. I just wanted to bring... No, we have got 2 minutes. I just want... You see, honorable members, there is a day we had the motion from Honorable Bertha, Honorable Willem, and I don't know who's the third one. And I thought we have synergy of understanding in terms of motion. That the motion must just be the intent, and then the elaborative prefix to the motion must come during the motivation. Now, I don't know, that's why I said maybe we need to guide each other. How should we bring each other on par? I think others are maybe issues we can live about, but the consistency in terms of what we need to do, help the table office and the presiding officer, what needs to be done, so that we understand that the motion must just contain the footnote if I may put it like that, and the elaborative explanation must come thereafter, so that at least we create a consistency what needs to be done with reference to motions. I think I just put it as a footnote, maybe as a footnote. I know Honorable Ampanda is there, Honorable Swatbo is there, but let's help each other offline, you understand, so that the presiding officer will always be in conflict with other members. Others will comply, others will not comply, others will take 5 minutes, others will take a minute. How do we deal with that going forward? With that, we break for tea break until 4 o'clock. Thank you very much. Thank you. We left a message from the head of state, ministerial statement. Now we come to the orders of the day. The secretary will read the first order of the day.
Of debate on second reading, land bill.
Thank you very much. When the Assembly adjourned yesterday, the 30th of September 2024, the question before the House was a motion by the Honorable Minister of Agriculture, Fisheries, Water and Land Reform that the bill be read the second time. Honorable AMTA adjourned the debate and he now has the floor.
Thank you very much, Honorable Speaker, honorable members. I would start with my contributions on the definitions. And I want to say this is a good bill. I support it with the following suggestions. And Section 1. Section 1, at the definitions, there is a term spouse, which also include the word partner. It is my view that the word partner under this definition of spouse must either be removed from the definition of spouses or expanded, the definition about partners expanded, because this could as well include anybody who's a partner because it's a girlfriend or a boyfriend or a partner in any way. And I don't feel that the Act should definitely give an obligation to the holder of the right in terms of being, being a spouse. So an expanded definition is needed in this aspect. And also with definitions, there is a child. A child here does also include a child under the guardianship and also a stepchild. I feel that the Act must not give an obligation or a commitment to the right holder when it comes to the inheritance of right of this land. And therefore, this inclusion of a child under guardianship or stepchild could be removed, in my view. And also Section 23, that deals with the prohibition of fencing in communal land. This section prohibits fencing of or causing to erect a fence on any portion of land situated in a communal land area. That is a problem to me. I believe that people must have a right to fence off a portion of land where they want to protect the areas such as crop fields, so that they prevent them from destruction by animals and so on. And I also believe that because these people have already been enjoying the benefit of having a fence around their mahangu fields or crop fields, the Act must not reduce or diminish that benefit that have been enjoyed by people living in communal areas. A good law must always seek to improve on an existing right or benefit. And I believe that this section must either continue to allow people to fence off the field where they produce crop, any kind of crop, and because if you have a portion of land in a commercial area, you are allowed to protect it. you are allowed to protect it. So that is section 3. Then I go to section 34. This one is saying it prohibits dual grazing. I believe in communal areas. I believe that if you give right to a Namibian who lives in commercial area to have multiple areas for grazing, but a person who has 20 hectares in a communal area, you say he or she must only have one area, one portion of land to graze from. I have a problem with it. Because as it is now, people are allowed to graze not only at one place. You can have your portion of land here where you produce your crop and another area where you graze. Because it's only 20 hectares in a communal area. So this one must also be amended. This one must...
Come again. Read it. What does it say? A member may speak, may, not shall. Yeah. So that's what I'm saying. A member may speak on a question, on a point of order or point of privilege. Yeah. What is the point? On which one are you standing?
On the point of privilege.
Okay.
Yes. The gist of it, Deputy Speaker, is just that there are valuable contributions that are now being made by a member, and the sponsoring minister is not here.
Okay.
Yeah, so I'm just wondering to see, because now this is our actual work. It's not notice of questions, it's like serious work. The person is talking about clauses. If you can be assured that these notes are being taken, wait, it's land, man, not. So if we can be assured, I'm just concerned that valuable contribution, he's talking about definition, he's talking about all those, maybe you can guide. If it's okay, then it's fine. I'm just a bit concerned.
Okay, for the second time, Honorable Ampanda, all the deliberations here are recorded verbatim in the Hansard. And it's upon each and every ministry, once a bill of this nature is, to make reference to the verbatim contributions of every member. So nothing is lost, whether the minister is here or whether the minister is not here. And we are even in an age, digital age. Who does not say where the minister is, she does not log in and follow the contributions. As a responsible person, she knows a bill is on the floor. She might log in, she might not log in, she might play the delayed recordings, she might come and check the recordings. But as I said, the verbatim recordings is there, and that's why the parliamentary system follows the Hansard. Okay. Now, I don't know how many minutes we've eaten now.
Yes, Honorable Speaker, but I also have then a question, because are we not having 15 minutes for...
How many?
Under Rule 85. Is it not 15 minutes?
No.
Where is 3 minutes, 5 minutes?
Yeah?
Because I thought
it's
we
15.
Are... Yes, it's 15.
Let's go there. It's rule?
Yeah, 30 for the mover. 22 and 15 for me.
Which rule is it?
85.
85. Okay. Yeah. Technically, but it says first reading. The heading. And we are at second reading.
Yeah, but which is a committee of the whole house.
You are a seasonal member, please. Committee of the whole house, then the presiding officer sits there and goes through the adoption process.
Yes, but I say now, where we are.
We are where?
It's actually...
We are at second reading.
Where is it provided for here?
That's why I'm saying, when the 15 minutes.
Yeah, well, it's 15 minutes then, because...
But for first reading, I think the book is wrong, and maybe also...
What is guiding you, Honorable Chair?
The first reading, is the introduction by the minister.
Yes.
Isn't it? That is the first reading. And then after the introduction by the minister, the next stage is second reading. I think there is an omission in the book because it does not capture second reading.
Yes.
Now we must apply
15 minutes.
reasonability in terms of the rules and see the mistake.
Yes.
Isn't it?
Yes.
We agree?
Yes, we agree.
So for this stage, and then we must also apologize to the minister. Isn't it? Because yesterday we have given how many?
Yes.
How many?
We gave less than 30.
Okay,
Yes.
we give a 15, 12
Yes.
plus 3, but I think we should have given a 30.
Yes, we could have given her 30.
30
yes.
as the mover.
Yes.
But it's because in the allocation, second reading is not captured.
Thank you
But I
very-
think that first reading refers to second reading.
Thank you very much for your understanding, Honorable Deputy Speaker. I was busy with section.
No, luckily you are the first person. I think we will stick to.
Yeah, it's
I'm
15.
improvising. It should be 15 minutes.
Yes,
because
now
the
it's
first
10.
reading is just for the mover, which will be 30 minutes.
Yes.
And then after the mover has tabled the bill goes automatically to second reading.
Yes.
So this stage where we are is second reading. But the rules book does not have second reading. I think that printing error of saying first reading should go to second reading.
Yes.
Yeah. Because members only contribute during second reading.
Yes.
You don't contribute during first reading.
Precisely, Honorable Deputy Speaker. We are at second.
Oh, yeah, no, it's there. All please. Yeah, second reading. No, so then we are right.
We are right.
Okay.
15 minutes.
Yeah.
So 10 minutes left.
Yes.
Yes.
Okay. Come again.
Your mic is not on.
It says all bills except Okay, now it's English. Let's just pause here to get consistency. Huh? Let's just pause and interrogate this to get consistency so that we the way I understand it, and thank you, Honorable Mubita, it says all bills except appropriation bill. So that means what we are reading here, that 15,
Yes.
of yours, it's for the appropriation bill.
No, it says except.
Except
all
the
bills
appropriation
except.
bill. Okay.
Yes, 15 minutes.
Okay.
Yes.
No, just wait. We'll come. I want us to be clear.
Yes.
Yes. Let's help each other so that we create a baseline together. Okay. Is it 50?
Yes.
Honorable Wise?
It's 15.
Okay. It's 15. Okay. Dr. Mbita, you are off. Okay. No, you are the one who stopped the proceedings, so I just want us to be on the same wavelength. So what we are saying is, where we are is 30 minutes for the mover and 15 minutes for every person once. Okay.
Yes.
Thank you.
Can I continue?
Yeah, you continue now for 10 minutes, and every other person thereafter will be 15 minutes. Okay.
Thank you very much, Honorable Deputy Speaker. I was busy with Section 34. Section 34:11 speak about the prohibition of dual grazing in communal areas. Honorable Deputy Speaker, honorable members, I think there is room to improve on Section 34 because denying people living in communal areas the right to have dual grazing, which they are already enjoying as we are here now, and which they have been enjoying over years, and now we are reducing these benefits of enjoyment. I think it will not be good. Therefore, there is need that we amend this one to allow dual grazing to continue the way it has been continuing over years. This one is saying that is when a person is relocated or perhaps resettled in a commercial area, then the land that you had in a communal area automatically cease to be yours. That right cease. And that's why I say no, it wouldn't be the correct one. I believe that we can amend it so that these people enjoy that right. It's also saying if you have another, or you get another portion of land in a communal grazing area, so you relinquish automatically the other one that you had, so, which is also problematic, and I think we should amend this one on the floor so that it can allow people to graze the way we have been grazing in Namibia. Now, yes, we move to, then we move to fencing. That is again section 23. It is saying once this act is gazetted, then it may cause some of the fences that have been existing protecting crop fields being required to be removed, because it's saying it should actually no longer be fenced off. And I'm saying this cannot be good to our people, and therefore those existing fences must be allowed, and we can amend this on the floor to allow it to continue being protected. The last one is on section 36. That is the right to lease land in a communal area, the leasehold, because we have a customary right, and then I want to target the leasehold itself. Because I thought, as we want to improve on the livelihood of our people, we would bring an act that would definitely give them a certain better benefits than now, so that they can have a right of land which they can use maybe for collaterals, bankability, to address the question of bankability. Because at the moment, a person who is in the commercial area will continue to enjoy the benefit of using the land for collateral, whereas the person who is in the communal area doesn't have that benefit. And then this act, I thought, would bring that element to allow people living on the other side of the cordon fence also to benefit equally from the land. And therefore, I suggest that section 36 also be amended so that it can include the element of bankability, so that the person holding a leasehold in a communal area can use either a portion of the land for collateral purposes, so that we don't continue to have a situation that produces a generative poverty to the future generations. They must be able to benefit from such a land. But I want to comment the Honorable Minister for especially section 35. Section 35 will now prohibit foreigners to acquire land rights, especially in communal areas. They can't get it anymore. And I want to say it is actually good. It's something that we have been looking for and waiting for a long time. And here is just a comment to say it's a job well done. So, Honorable Deputy Speaker, and the whole House, I thank you very much for listening to me, because when I prepared, I was having in mind 5 minutes. But today I realize it's not 5 minutes. But be it as it is, I thank you very much and I support this bill.
Thank you. And I recognize Honorable Amtenya, 15 minutes.
Honorable Deputy Speaker, I will speak in less than 15 minutes in support of this long-awaited bill that would obviously, and I believe this August House would be fast to get the bill through. But I want to really support it starting from Section 6 of the bill, which recognize or which really look at the improving the communal land board composition. And I want to really recognize those improvements that are made on the communal land board, especially the inclusion of a legal expert appointed from the Ministry of Justice, so that we close the gap of legal expertise in the land governance. This is really recommendable or commendable, and it's a great thing that would improve our land governance. However, I have a concern on the composition of the communal land board that I propose that we need to review it, because Section 6, subsection 1 enforces inclusion of at least two women, yeah, and it's leaving out the youth. And honestly, Honorable Deputy Speaker, the youth are the key custodian of our land. I really want to, yes, we are the ones that work on the land, and I want Section 6, subsection 1, Roman 3, those two, because we are talking about two, at least two must be women, at least the other two must be youth, so that young people can as well be part of this land board. The other thing also, I think we need to also to make a distinction when by just referring this communal land board as communal land board, because when you look at the operation of this communal land board, it's at the regional level. So I propose that we refer the communal land board to as regional land boards, because that is the operation, so that it also gives a proper distinction. Another thing is possibly to look at the tenure of this board, because it speaks about 3 years, which is quite very short, yes, that the board may not be able to, fully implement their operations. Therefore, I propose that we consider the 3 years tenure to be improved or increased to 5 years tenure. Another contribution, Honorable Deputy Speaker, I think this one I'm answering to my Honorable Senior on the aspect of the bankability of the leasehold in communal area, which from my observation I found it covered, because when you look at Section 39, subsection 5, it makes provisions that a lease for a period of 10 years or more can be surveyed, and the leasehold can be registered in accordance with the Deeds Registry Act. And in that, I think obviously that means that the lease can be used to secure financing. That can be done for capital investment either in agriculture, in tourism, and obviously infrastructure, which for sure is going to see development in our rural areas and employment creation, because then the owner of that may obviously improve that. If you look at Section 39, subsection 5, I strongly believe that it closed that gap on the leasehold. I ought to be directed or corrected if my judgment is not in line. On the other side, the other issue is also on the resettlement farms. When you look at, we obviously have the aspect or that gap within the current act, where beneficiaries remain obviously long-term tenants, but they do not have clear ownerships when it comes to the current act. However, this bill is providing the pathways for resettled farmers to eventually acquire the farms they lease. They can acquire the farms that they lease. The bill also creates security of tenure, and yes, that is Section 118, subsection 1. If you look at that, it says a lease of a farming unit may apply to the minister to obtain an option to purchase the farming unit. Yes. I'm not generalizing. I'm referring you to...
You see, honorable member,
yes.
you have got the floor. This is second reading. You can contribute.
Then they must keep quiet. Yes.
No, hello,
So,
hey, with throw that one.
No, Speaker, they must keep quiet because they cannot interrupt me. They must keep quiet when I'm speaking.
Yeah.
They cannot interrupt me. They must keep quiet. Yes. Deputy Speaker.
Yeah.
So when you look at
But
section...
you must also not listen to them. You must listen to them.
No, they are disrupting me. They must keep quiet. I'm the one. I have the floor.
You have the floor.
Yes.
You have the floor.
So when you look at section 118, subsection 1, it says a lease of a farming unit may apply to the minister to obtain an option to purchase the farming unit. Whatever it is, Prof, in your own area, that is what you do. And then the farming unit consent at a purchase price, which is equal to the market value of the unit. So this at least, and it even gives an option for 5 years. Those that have acquired or that got a lease 5 years back, if we are to implement this act, obviously they would also benefit, and they can actually be able to purchase their farms. And in fact, that means also the bankability comes in when it comes to the resettlement farms. It also comes in, it's also covered by section 108, subsection 2, where it obviously says the minister must cause any lease referred to in subsection 1, which is for the period of 10 years or more, to be registered in accordance with the Deed Registries Act. I think the Deed Registries Act here obviously allows one to obviously can obviously get collateral and have that. So I think that is my understanding on this matter. So, Honorable Deputy Speaker, the other part that I really want to acknowledge is the establishing of land committees that is indicated in section 26, which is something quite new that allows the minister to formally establish land committees, more especially in traditional authorities where there might be disputes or the traditional authorities does not exist. So it allows this committee, land committees, to handle the aspect of land while then either those disputes can be resolved. So I think this allows obviously the community to benefit and have the land issues resolved despite the disputes or the absence of the traditional authority. Otherwise, in short, Honorable Deputy Speaker, I so support this bill, and I also encourage that as we go through, we support the bill, and thank you very much.
Thank you. I now recognize Honorable Nashinge. In terms of the rules, 20 minutes, but because yesterday you took 3 minutes, we can subtract it.
No, why should we deal with yesterday? Today is today.
Oh, today is today.
Yeah.
Honorable Nashinge, 20 minutes in terms of the rules.
Thank you very much, Honorable Deputy Speaker. I'll be short. What I wanted to encourage is that this House, the 8th Parliament, to really commit ourselves to do justice to this bill. We must all support it, but we must not support it just because we must support. I want to conclude that some of the honorable members probably got it before us, and they went through already. And I would want to suggest that there is a lot of work that needs to be done, and also we have to read it with other laws of the Republic. We can't read it in isolation. I mean, if we look at, for example, the constitution of the Commission, which is going to advise the minister on what to be done, it's appointed by the minister, repeating the mistakes of what we have done before. So I truly just wanted to suggest that we give ourselves 2 weeks and all of us commit to ourselves reading it properly and comprehend, and come back and finalize our work as fast as we could. So I therefore propose that we propose to the 22nd of October and come back and finalize at a level where we are all going to be happy and satisfied that we truly understand Because if you look, for example, at, we are still limited to the areas that were established before our independence. But who says we can't go and establish a habitat, something between, let's say, Ocho and the borders of Opuo and Umsati region, for example? Because we are all just stuck here, limiting ourselves from enjoying our country. I'm done.
I want to help you. I want to help you for future.
No, I hear, but with my time, why do you want to limit me?
No, because you are trying to postpone so that next time you have eaten up your time. And you say here it says once.
No.
So if you use...
I hear you, I'm done.
You are done.
Yeah.
So next time you are out, 20 seconds, is what you mean? Yes. No, I want to deal... You see, that's why I wanted to help you, Honorable Member, to say there are other members who are ready. You have eaten up 3 minutes. If you wanted to postpone to 20 seconds, you just postpone. Then you keep your 20 minutes. But now, you have spoken once, you want to come back again at the 20 seconds again to participate. Yeah. Karunga kanje. Okay. Yeah, you see, honorable members, I understand, but I'm saying where we are, I think we have created synergy of understanding. You are entitled to postpone, honorable members. If that's your intention, just postpone, and then you don't eat up on your time. Because there are 2 issues there to be taken care. It's the frequency of ones participating and the time. Now, if you use 3 minutes instead of 20, you have used the opportunity once. It becomes difficult. But that is said and done. I'm sure going forward, members will take note that you have got 15 minutes and you have got a once participatory, no, not twice, once. So I will now recognize Honorable Lucato.
Honorable Deputy Speaker, honorable members, thank you very much for the platform. I'm going to use that few minutes and I have to be done. Yeah, thank you so much. My contribution on this, I will support this bill 100%. The reason it's, it's a benefit to all the Namibian people, the masses of this country. So it will benefit, this bill will benefit. Yes, then let me say, traditional leaders in Namibia, those who are already recognized by the government or cabinet, according to the resolution of the Second Land Conference, where I have been participated, we have agreed that traditional leaders should be provided with land and also to build their houses in the towns where they live. Then also, my second point is that all church leaders or church in Namibia, which are recognized by the state, should also provide or resources to build their churches, and also to provide that they have to build their offices. Because church, without church, we could not be here, because God He provided that. So the message of God should be a voice of protection of Namibian people, or the whole world. God, yes. Then also the last one, the last second, is that On the social, we have social groups in Namibia. Those social groups including our youth group, those who are poor. So if they go to any, whether it's rural or urban, they should be provided with accommodation. State should build flats for them when they seek employment, when they seek other things in order to live. So according to the resolutions of the Second Land Conference, so also it's there. We have agreed and approved. The last one, all those laws or resolutions for Second Land Conference, which we have approved, because all Namibians were represented, including politicians, churches, traditional leaders, and all other stakeholders. We have agreed that those resolutions should now be implemented to be included in this bill, so that the Namibian people, they can benefit. And those, I'll be very happy that all those resolutions should be in this bill. And I'll make sure that if those resolutions are not in this bill, I'm not going to support it. Yes, but I'm going to revoke my support. Yes. So now I support the bill 100%. I thank you, Honorable. Yes, yes.
Thank you, Honorable. Yeah. Now, I don't know whether the member supports because he says he can revoke. So now, so you make me difficult. I must report progress to the minister. Now I will say, Honorable, what is it? Amutse, Honorable Velem, Honorable Rugato supported, but now the one of Rugato. That was just in passing, not to comment, not to comment. Okay. Thank you, Honorable Ngari.
Thank you very much, Honorable Deputy Speaker. I seek the indulgence of the House to have this particular debate postponed to the 7th of this month, which is next week, Tuesday. Thank you.
Tuesday. Okay. Any other? You want to, or you also want to postpone? No, if you want to, no, the postponement will stand under Ina, Honorable Ina's name. But if there are members who are ready to utilize the 15 minutes, we can still do it. Okay. Honorable Bakera. Just wait. It must be read.
I rise in support of the very important bill. I want to concur with Honorable Amutenya on section 8, term of office for the members of the land board. That the period of 3 years is very short. Coming from the regions, we've experienced that mostly while there are disputes, the term ends and there is no institutional memory in terms of continuing with the work of the board. So I would propose that it's been aligned to the term of office of the Lands Tribunal, that is 5 years. And on the Chapter 5, Lands Tribunal, Section 158, subsection B, where it's talking about the legal qualifications and experience in the legal profession, whether in private practice or in legal environment for a period of at least 10 years, that will exclude our youth. Because if you say that the person must have experience of 10 years, it really will exclude the members, the young people of the society. So I also would like to propose that we maybe must reduce the period of experience maybe up to 5 years so that the youth can partake also. So I will submit and I'm in support of the bill. Thank you.
I recognize Honorable Ausiku. Ausiku, out.
Thank you, Honorable Deputy Speaker. I rise to support the bill and also to thank the Honorable Minister for tabling this long-awaited bill. I will also be short. I have noticed that under Section 6, I would like us, if possible, if the bill can include a representative from our conservancies. These are some of our stakeholders who are left behind. Further, under Section 23, my colleague, Honorable AMTA, have mentioned something which I also support. However, I have a concern under subparagraph 2. On the illegal fencing, it mentioned about the board, but nothing is mentioned about our community members who are normally affected by illegal fencing. They are not considered, their complaints are not taken into consideration. I think the recommendation should not only come from the land board, but it should also have an inclusion of the consultation of the approval of the affected community member. In the Kavango West region, there have been a lot of problems where people just come with the support from the land board, and this ordinary community member, they lose their land. Under the proposal of land committee, although my colleague Honorable Hamtenya also came in, I have a different view. I have a concern if this section will not create conflict among traditional authorities. I know it is being referred to unrecognized traditional authority, but those authorities also have followers. So we should try to avoid the concept of unrecognized. Just like we talk about illegal schools, we must avoid those terms. We have to try to really assist those communities, even if a traditional leader is not recognized. They have followers. Finally, Honorable Deputy Speaker, this is in the form of a question to the Honorable Minister. Section 27, application of customary land right. The 5 traditional authorities in Kavango West and Kavango East, they have a strong position on this section. I wanted to know if they were fully consulted and what are their views on this section. Thank you, Honorable Deputy Speaker. That is my contribution.
Thank you. I recognize Honorable Shimi.
Thank you very much, Honorable Deputy Speaker. Let me also join my colleagues who have congratulated the Minister for tabling this very, very important bill. In fact, it's long overdue. And I will definitely be one of those who support this important bill. One of the things that were flagged and attracted a lot of debate during the land conference was the bankability of leaseholds in communal areas. Because people felt that, you know, if I have a property here, even if I have a leasehold here, I can go to the bank and get money to develop that property. But our colleagues in the communal areas do not have that right. So one of the resolutions, Honorable Deputy Speaker, of the Land Conference is really to make leaseholds in the communal area bankable. And how do we do that? And I'll just give you one example before I propose a solution. So if you go to Osengate today, it's a green belt, you know, we are producing grapes there. It was not like that 30 years ago. It was just barren land which was there. And if you go there, you find people from all over Namibia, but mostly people from Kavango, the western part of the north, where you also find rivers, you also find land, but you don't find similar activities, agricultural activities there. The only difference is actually the land, the security of land in the communal area. If we can strengthen the security of rights and in this case leaseholds in the communal areas, we will make these leaseholds in the communal area bankable. And therefore my proposal is, Honorable Deputy Speaker, I have read the bill. It has addressed some aspects of this need, but I believe Section 40 needs to be strengthened to make leaseholds bankable in the communal areas. I have specific suggestions to make, to give to the Minister, but I think this is a very, very important section that needs to be strengthened for us to be able to attract more economic activities in the communal areas and create the needed jobs, employment opportunities in the communal areas, and also give more or less our colleagues who live in the communal areas, you know, some kind of tenure security when it comes to the leaseholds that they have. And here I'm not talking about the customary land rights. I'm talking about leaseholds that are approved by the land boards, first of all by the traditional authority, and then after that by the land boards, come to the Minister of Agriculture, registered in the deeds office. So if we can just strengthen that process, we will make communal area bankable as per the resolution of the Land Conference. So that's my submission, Honorable Deputy Speaker, and I wholeheartedly support this bill.
Thank you very much. I don't see any other contribution. I will now give the floor to Honorable Hengari to postpone officially.
Speaker, I hereby postpone the debate to next week, Tuesday.
Thank you very much. Yeah. Thank you. Thank you. We have disposed of the first order of the day. I will now call the Secretary to read the second order of the day.
Resumption of debate to provide direction on the ACC and the appointment of its Director General and the Deputy Director General, among others.
Thank you very much. When the Assembly adjourned yesterday, the 30th of September 2025, the question before the Assembly was a motion by Honorable Kampala that the motion be referred to a Parliamentary Standing Committee for further investigation and report back. However, Honorable Shitana deferred the debate and he now has the floor. Yeah, no, we follow the blue one. The blue one has now come. Okay. Okay. Honorable Shitana, you know now it's 5 minutes. Ne? We are down from 50. Bills is 15. Let's not...
Yeah, I hope you are not taking up my time.
No, it's starting now.
Thank you, Deputy Speakers. In contribution to this motion, I wish to underscore the agency of reforming the Anti-Corruption Commission Act. Corruption is not a victimless crime. It robs ordinary Namibians of their right to quality health care, decent housing, accessible education, and equitable opportunities. When public resources are diverted for private gain, it is the poor and the vulnerable and the unemployed who suffers most. Other countries have already taken bold steps in this regard. South Africa is considering
reform to strengthen the independence of its National Anti-Corruption Advisory Committee. Botswana, Directorate of Corruption and Economic Crime, it's a model of proactive investigation empowered with strong independence process. Ghana has an Office of a Special Prosecutor established for specifically to fight corruption, free from executive interference. Australia, National Anti-Corruption Commission, demonstrated how a structured appointment process supported by the parliamentary oversight can safeguard impartiality and credibility. Namibia cannot afford to fall behind. Our ranking of 59 out of 180 countries in the 2024 Transparent International Corruption Perception Index shows that there is much work to be done. If we fail to reform, I repeat this one again, if we fail to reform, we risk normalizing corruption in Namibia, eroding public trust and discouraging both domestic and foreign investment. Honorable Deputy Speakers, honorable members, reforming the Anti-Corruption Commission is not about creating a new structure for the sake of it. It is about restoring integrity by ensuring appointments are based on merit, not political loyalty. Protecting democracy by isolating the ACC from undue influences. Promoting accountability, making the Commission answerable to the Parliament and by extension to the people. Strengthen the rule of law by ensuring corruption cases are investigated without fear or favor. As a Parliament, we have a responsibility to champion reform and ensure that transparent governance across Africa. Legislatures are rising to challenge of institution building. Namibia must not count among those who are willing to move from rhetoric to action. In conclusion, supporting this motion, it's about defending the dignity of our republic by reforming the law governing the Anti-Corruption Commission. We can ensure that it is become a genuine guardian of accountability, independence, and transparent and effectiveness. My 2 seconds, I want to urge this House that making laws that are more partisan is not safe to anybody. Making laws that are more benefiting any Namibian is the best way for anybody, because a table can turn. I submit.
Yes, I now recognize Honorable Lengari.
Thank you very much, Honorable Deputy Speaker. I rise to contribute to this very important debate on the Anti-Corruption Commission, or rather its leadership, and the process of appointing. I think Article 94A speaks of the anti-corruption, but more importantly, in a larger point, probably 94A sub-article 6, which speaks of the appointment process of the Director General and Deputy Director General of the Anti-Corruption Commission. One of the conversations that we had and that we've been having in the corridors of this Parliament is with regards, of course, to the process of appointing the Deputy Director General and the Director General of the Anti-Corruption Commission. At some point, we asked the question whether the appointing process was the one that we had to perhaps amend and look at, or whether leaving those powers with the President, the nominating powers to appoint these individuals, was the bigger problem. Now, if I may, the Article 94A says, 94A sub-article 5 says the National Assembly shall appoint the Director General of the Anti-Corruption Commission and the Deputy Director General upon nomination by the President. I've always been of the view, at some point I actually thought that that provision was, or that article was problematic. But I was later convinced by a colleague who said, it is not so much the provision, because the article says the President nominates these individuals, but it is Parliament that appoints. So it then becomes a question of institutional ability. Is Parliament in a position, institutionally, do we have the capacity, whether it's vetting capacity, whether it's a vetting committee of some sort, that looks into the names that come from the President? Of course, it is entirely up to the President to say, I'm submitting 2 names, or I'm submitting 3 names to Parliament to appoint these individuals. But the appointing authority lies with Parliament. So I think this question needs to be asked from an introspective perspective. Can we say, as Parliament, as an August House, as a law-making institution, that we are in position or in a place to actually appoint or exercise this particular authority that is offered to us in this particular provision? And I think the answer is no. And so I'm going back again. Is it the provision that is problematic, or is it the exercise of the powers that is accorded to this House that becomes problematic? I have a recommendation. I think the committee or whoever is going to deal with this particular topic needs to consider how we can reform Parliament as an institution so that it is in a better place to exercise this authority, because it is not enough to say the names have been nominated and submitted by the President, and therefore our duty is only to rubber stamp and appoint. I think if you take a deeper look and introspect, I think there is really a necessity to build this institution so that it is able to exercise this authority. So my recommendation 1 is to have a vetting committee of some sort, and how we are going to come up with the composition of that committee is entirely up to us as members of this House. You say, are we going to ensure that there is representation from all political parties so that those members sit on a vetting committee or vetting board that looks at those names? Because I don't think it says anyway that the President is only mandated to nominate 2 individuals or nominate 3 individuals. I think those powers are entirely or sit entirely with the President. But what we can do from our side is to say, how do we ensure that we are in a better place to exercise this authority? 2, and very quickly in this 30 seconds, there are deeper institutional issues and administrative issues with the Anti-Corruption Commission. Year after year, monies are allocated to the Anti-Corruption Commission. But I think those of us who are very alive to the issues of this country and who have been following, even with a recent case in court that is being dealt with by the Anti-Corruption Commission, you realize that there are administrative issues and there are institutional issues that we can also, I think it's important that we also involve those issues as we look at the Anti-Corruption Commission and making this institution function and exist beyond individuals. Thank you.
Thank you very much. I now recognize Honorable Kandorombu.
Yeah, thank you, Deputy Speaker. Let me give my contribution to this very important motion in support. What is currently happening in Namibia it's completely something different. The Anti-Corruption Commission, the director and the deputy director, they suppose not to serve more than 10 years.
even 10 years is more. 5 years is enough. So I will propose that the appointment of the Director General, of the ACC Director and the Deputy Director, it must be between 5 and 10 years. And the peoples to be selected must be a magistrate or a judge, someone with a background, with a legal background, so that after the term, he or she can go back to the bench and continue operating. Because the current status quo, we fear that at times this top team connive with perpetrators of corruption. And as a result, their cases are always kept underground, or the response that we are getting is they are cleared from any allegations. The issue of Fish Road is very clear. Those in custody now, first, the current director have cleared them of any wrongdoing until Al Jazeera exposed the entire corruption. That's when we wake up out of the bed and say, oh, something bad is happening. The same with current NAMCOR. They were cleared. There are many other related cases. So the public at large, including some of those at the side of the appointing authority, they are complaining that anti-corruption is not effective. Anti-corruption is conniving. So therefore, we need to give time limit legally. Now, when it comes to the process of appointing at Parliament, I think first we need to put our house in order, because our own staff, we don't appoint them. They are under Public Service Commission. So we need to bring our own commission in place so that some of these legal duties, responsibilities, are included in the commission that will be responsible with parliamentary appointments, starting with anti-corruption up to our staff member at Parliament. I so submit.
Thank you. I now recognize Honorable Likwato.
Honorable Deputy Speaker, members of Parliament, thank you very much for the platform. I just want also to contribute to Anti-Corruption Commission, Article 94A, read with the amendment, second amendment of Act 7 of 2010, chapter 10A. I just want to put it like this. Let me start with the formation of the Anti-Corruption Commission in Namibia. The question is that who established this commission first? Whether it's the executive, and if it is the executive, so others like other stakeholders were not part and parcel of this formation. Then that's why the amendment of Act 7 was done. Now, this commission, it should supposed to serve Namibia as any independent commission. But unfortunately, since the establishment of this commission, it's not independent. The Director General reports to the sitting president. The appointment of the Director General and the Deputy or Second Command whatsoever, they say the Parliament should appoint. I think what happened that the Parliament, if they nominate, or those nominations, names, it comes to the Parliament. From there, it goes to the sitting president. Then after that, who appoint them is the sitting president. So I'm having a problem that it's not independent. Then let me recommend that in order for the anti-corruption of Namibia, it should be fully independent by amend the current Article 94A in order to have an independent anti-corruption commission. And that commission, where should that commission report? My recommendation is that it should report to any independent body, not to the sitting president, but to independent body. So my recommendation that who are those independent bodies? Who are those? So it's Namibian people, stakeholders, parliament, to come together that a conference should be held, because those anti-corruption commissioners or director whatsoever, they should be free from any political influence. They should come from people who are not carrying any political tickets. So in this regard, I support this motion that 100%. Thank you so much, Honorable Deputy Speaker.
Thank you. I now recognize Honorable Shimi.
Thank you very much, Honorable Deputy Speaker. Honorable Deputy Speaker, key to solving any problem is always important to diagnose the problem, because we seem to be thinking that there's a problem somewhere which doesn't seem to exist. So I think it's important to understand what is not working and what is working. So if we look at the appointment of the Director General of the Anti-Corruption Commission and the Deputy Director General, it's a constitutional provision. It's in the Constitution. So in that Constitution, in the Constitution, it's clearly stipulated that the President nominates, Parliament or National Assembly appoints. So the appointing authority best, or the authority to appoint best with this Parliament, with the National Assembly. So I think that must be clear. The President only nominates, and National Assembly appoints. So if there are people who have to be, if National Assembly has appointed wrong people, it's a National Assembly that has to take that responsibility, because the final authority lies in this House. That's one. The Anti-Corruption Act, Section 4, also stipulates the qualifications of the people who qualify to be appointed as the Director General and the Deputy Director General. So if you go to Section 4, I think I have it here, it tells you who qualifies, and it says people who have been convicted of forgery, people who are not Namibians, people who, there are specific qualifications that are there. So all these details are in the law. I also heard some members complaining that, the tenure doesn't seem to have been defined. The law is very specific, both the Constitution and the law. It says for a period of 5 years. Of course, that can be renewed. But again, that's a prerogative of the National Assembly. If you believe the Director General and the Deputy Director General are doing a good job, it's a prerogative of the National Assembly to renew their contract. But the period is limited to 5 years. So that is already provided for. So I believe, Honorable Deputy Speaker, the appointment of the Director General and the Deputy, it's one of the unique and few cases where you actually have two organs of the state participating. In many cases, including the appointment of many of our key positions, it's only one entity or one organ of the state that is involved. In this case, we have two organs of states. Why? Because we want to make sure that this process, it's watertight, this process is thorough, and therefore it's important to recognize that our laws and our constitution has already made provision for that, so that that process is thorough. So if there's anything that we probably need to change, if we think that maybe the process of nomination needs to be strengthened, we need to start talking about that. But not asking who is appointing, because that is already clear. You are the appointing authority. And therefore, let's see what still needs to be strengthened, and maybe the nomination process can still be strengthened. We can look at that during the committee discussions, but I think the process is well spelled out, Honorable Deputy Speaker, in the Constitution and in the law. I so submit.
Thank you very much. I recognize Honorable Mouton.
Okay, so first of all, I want to add on what Honorable Shimi is saying, and then also to point out an obvious flaw. So we say that the President can select, let's say for argument's sake, 3 people, and Parliament appoints. But we must remember that the same ruling party has majority in Parliament. So if the ruling party wants a specific candidate, there's nothing opposition can do. It will just be rubber stamp. I'm going to make an analogy.
Honorable members, please, no, please. No, the member is entitled. No, please, honorable members.
My time, Speaker.
Yeah.
My time.
You see, no, honorable members, I don't know what is. No, what is the infringement? No.
About corrupt people, they don't.
But honorable members, let us be casual and to the level of listening to each other. This is a debate that carries different divergence of opinions. Yeah, allow me for the sake of progress.
Why are you reacting?
Yeah. Honorable Moton, please, you have the floor.
Thank you.
Yeah.
So it's an obvious fallacy. We pretend as if the two work separately. You know, the thing is, we are monopolizing power within the president, and this is things that are becoming even more and more authoritarian. So I'm going to make an analogy. We always say, yeah, the players and the referee, that analogy. So let's, for example, say that you have Manchester United and Liverpool. Right?
Arsenal.
Okay, let's use Arsenal. Okay, so Manchester United's manager, he chooses 3 referees. The manager, the 3 referees, the manager of Manchester United have chosen. He knows all 3 of those referees will benefit his team. And then he gives it to his team to vote between those 3. So Manchester United as a team, they vote, we want this referee between the 3. Do you think Arsenal will be happy with the choice that Manchester United manager put forward and the Manchester United team has chosen? No, they will not. It is not fair. If you are serious about corruption, then make the ACC independent. Thank you.
Thank you. Okay. Honorable Ampanda.
Yeah, thank you very much, Deputy Speaker. So the first question that we must ask ourselves is that what is the motion seeking us to do? It says 2 things. First one is to give direction to the ACC. That's the first area of competence in terms of what he's seeking. The second is speaking about this component that we are now debating. Honorable Kapofi and them, when they were in the bush, they used to have a song that when Namibia gets independence, it's going to be happiness for everyone. When they came here, they drafted a constitution, and when they drafted the constitution, they made constitutional promises. I'm educating you. So Article 16, for example, has that constitutional promise. It says that all people on earth will have a right to acquire property in Namibia, provided that Namibia would pass a legislation to regulate the ownership of land by foreign nationals. That promise has not been fulfilled until this week, when the minister tabled the land bill with that specific section in 123 and 143, not 100, but for section 43. What the motion seeks, if I understand it perfectly well, it is for us to further those constitutional promises. And Minister Shimi, it is not that the people are not clear. It says here in the Anti-Corruption Act, the same act, that the section that you are talking about, is that the National Assembly will appoint a person who's of good character and high integrity. What is good character? What is high integrity, and who's defining it? Is not defined. Yeah? And it also says that possess the knowledge and experience relevant to the function of the commission. So what the motion seeks us to do here, Deputy Speaker, is to do two things. Even if you decide that the president must do whatever, you are simply just trying to say, okay, in consideration of the nomination, there will be an advert, president will call for nomination, and this is the process. You are not taking away the right of the president to nominate. If the parliament appoints, you are simply just saying, no, there shall be some process that we are going to conduct. How does parliament appoint members of the ECN? Take those two processes. The public service, there is a committee that the public service, what they do, they interview, those interviews are done live and public. Even you as members of parliament, you can see. Then those nominations come to this house. Yeah? So when it comes to this house, there is a process that has taken place there to filter, to inspire confidence. Remember, the section 4 of the ACC Act speaks about a person of high integrity. Perhaps in the interviews, those questions of integrity will be posed. Those questions of good experience will be posed. We have no basis whatsoever. Let's imagine a president. Let's imagine a president who appoints the son. Nothing stops the president from appointing the son. The president, the current president, for example, have a competent son who's a lawyer, doing very well. What if the president appoints that son? Then you are going to be the first one to complain. But nothing says otherwise. In Malawi, if you don't learn from history, you are going to repeat those mistakes. One day, a president of Malawi came to a cabinet meeting, and he announced that he's jumping ship, he's establishing his own political party. Ministers were asked, are you with me or against me? Most ministers thought with their stomach and said, we are together, president. So the cabinet in 2 days shifted from the ruling party to a new party of the president. So it's very important for you to be able to understand that you need to be able to understand that what is it that we are asked to do here? We are asked to assist Parliament, National Assembly, so that we can have a proper framework to make proper decisions, like what we do with ECN. We are also asked to consider looking at the aspects of the president. What framework does the president follow? We are also asked to give direction to this problematic institution. How do we give it a direction? In what areas do we need direction? Even when it goes to the committees, those are the questions that we need to be able to ask. For instance, the ACC has a Department of Public Education. Should we add research to public education? Yeah? Should they do research on those cases? What has happened? If they are telling us they are apparently having 90 cases packed at the Prosecutor General office, is that the case? Why is that the case? So these are two elements. These are not semantics. Whatever way you do, whether you want to keep it with the president, whether you want to keep it with National Assembly, you just want to assure quality in the process of decision making, like other processes. And I hope that those discussions will continue at the committee. Thank you.
Thank you. Honorable Nashinki.
Thank you. Thank you very much, Honorable Speaker, Deputy Speaker. the timing is right for us as people of this country to truly have an honest discussion on the affairs and the setup of the ACC. Perhaps we should also add as to how it operates, as to how it deals with issues related to corruption, how they run after small fish while the big cats are enjoying through thievery. I think one thing that I would want to contribute and add, for example, is also the not only how we appoint, but the fact that the issues of anti-corruption is centralized in one room. It's called Anti-Corruption Commission. They have no one else that they report themselves to. They are the judges, and they are actually everything, the two. There is basically, at the end of the day, there is no accountability there. And I think that's one thing that we need to look into, to strengthen, to say you have judiciary, you have Namibian police force, you have even a parliament to at least to come up with to formulate a commission that can then serve as a body that this leader or the head of anti-corruption can be accountable to, unlike the way it is right now. The other thing, I think, the executive coming to decide to the legislature who I have appointed this one, go for him. I think we are giving the president too much powers. What Honorable Shimi said that is constitutional, yes, but who said it is forever correct? The Constitution of the United States of America, one of the mothers of the democracy that we are enjoying today, was amended for 27 times. Who says it is wrong for us to amend our Constitution to address some of these problems? We have seen the danger of corruption, how it has disadvantaged us from getting proper quality health care, proper educational institutions, and many other things. I mean, look at even, we can't even fix our National Assembly. I'm happy they managed to fix the bulbs. When we came here, it was very dark. Perhaps because of corruption, because money somewhere else that was meant to make sure that we maintain our infrastructure was stolen at the beginning of the food chain. So my input is that truly there is a need for us to amend and to take the centralized powers of ACC in the hands of one person and to involve other entities so that we are able to fight this corruption that is eating up our country. I so submit.
Thank you. You can just come in. Let me give Honorable Lizazi, Amutse, Honorable Amutse, Honorable Iemba. And then if you want, you can come in.
Thank you very much, Honorable Deputy Speaker. Though I am intimidated here by a senior member of this House, but I will not be because I'm bigger in stature. All right. The Namibian people are the ones at the receiving end of corruption, including myself and everybody who is seated here. So we need to protect the scarce resources that we are having in this country. That's why the commission was created, so that we can at least have someone who is going to protect the resources of this country. Article 94A5, I suggest that it should be specific. It should specify how many nominees. You can't just leave it like that. This was done on purpose. That's why they left it that the president can bring one person to leave the National Assembly with no choice but to endorse that person. This was on purpose. It was there
when you look at the intention of the drafter of this provision in the Constitution, they knew what they wanted to achieve. So it must specify, the amendment must be on sub-article 5, whereby there should be a specific number of people to be brought to us so that we know how to appoint or who to appoint. We can't have one person and we just come and rubber stamp in this house. So it's not going to work. The term of office as well, under sub-article 6, should also be specified because it should be linked to 5 term, because this institution is a very important institution. It should be specified that it should be 1 term only, 5 years, because when this person comes back, the person has seen the loopholes and they'll be able to come and steal. So and they are going to be also be working with the people who are corrupt. You have been here for how many years?
Yeah, just address the presiding officer. Leave the...
So,
just come in.
Even the issue of the names coming from, even the issue of the names coming from the president, it's not supposed to be like that. When we look at Article 90, sub-article 1, it's very specific. There should be a commission that recommends. The Judiciary Commission recommends the judiciary personnel. Why is this that it's only the president who wakes up when she's happy or not happy and take one person? No. There should be somebody or the commission that recommends names to the president. The process must be there, not one individual who wakes up one morning and give us one name. No. You don't want the truth. It will be said here whether you want it or not. We should also remember as well that we should also, the Minister of Finance, consider in increasing, because they lack resources. When they are well-resourced, it's like we are doing it deliberately to give them limited resources. If we give them resources, we capacitate them. We capacitate the commission. Let's give resources so that this commission can have the capacity to make sure that they combat corruption. That the pastor is doing, or was doing. Thank you very much, Honorable Deputy Speaker.
Okay, before Honorable Amute, let me hear you, Honorable
Speaker, I rise both on Rule 92 and 81st, and on a point of privilege, and 92 later on a point of order. Deputy Speaker, it's my understanding that during the debate, a member may raise a point of order. So I just want to understand your interpretation of this particular Rule 92 of the rule book.
Okay. I think Rule 92, that's why it's not the way Honorable Lizazi says one name. It has got 1 up to 12.
Yes.
All those are applicable to point of order.
Yes.
Now, and it says, amongst others, at 5. No, then you can read. That's what I'm saying. Now, point of order is when the presiding officer attention is called to a procedural matter. When the rules and orders are alleged to have been infringed,
yes.
As soon as the irregularity occurs in the House, in the customary proceedings of the House, to give an explanation in terms of Standing Rule 86, when you are personally named, to give an explanation, and seek clarity on a procedural matter. Those are the 4 conditions. according to my understanding. But it also goes further. It says, 5, if the presiding officer considers a point of order is spurious or frivolous, the presiding officer may direct the member who raised it to resume his or her seat. The presiding member may hear the opinion of other members. After the point of order has been stated, the presiding member who raised it, the presiding must give his ruling. The member may not abuse the right to raise a point of order so far as to obstruct the business of the chamber. You understand? Now, the presiding officer is also following. If I don't want to break the line of thought of the person on the ground, it is within the presiding officer's presumption to use that for the member to allow. And I'm always saying, whenever you interject a member here, the member always says, please hear me out before you give your ruling.
Yes.
That's what I'm saying. Now I'm also saying I'm expatriating that thinking also to the member that is on the floor. I want to hear the member out,
okay,
and then I will come to you so that we're done.
Okay.
Yeah.
Deputy Speaker, just one particular element.
And you know that the ruling of the presiding officer is not to be challenged.
Hopefully.
But you are doing that.
No, I'm not.
Yeah.
Honestly.
No, what are you doing?
I'm not. Look, Honorable Deputy Speaker, I don't think you've actually even made a ruling. All you did was read the rules.
Yeah.
And in reading your rules, you actually skipped. You skipped Rule 1, which says a member may raise a point of order at any point or time during the proceedings of the House. But you also skipped 2, 3, 4, and you jumped to 5. And I really just want to understand that. Because even if what you just said now applied, Rule 4, if you were to skip Rule 1, Rule 4 actually says, if the member does not quote, no, let's start at 3 or 2. When a point of order is raised, the member being called to order must discontinue his or her speech and take his or her seat. Yeah, and sometimes when we raise points of orders, it is not to argue with the member that is debating, perhaps. It is to provide supporting information to support the member's arguments in that debate.
Okay.
It's not necessarily to fight or argue with the member on the floor. And I think I remember even from our previous sessions that we would be allowed to raise points of orders, whether that is to seek clarity during a debate. But this is a house of debate. And I don't think it makes sense to only allow members to raise points of orders once another member has already taken their seat.
Okay, that's your view. I'm saying the entire rule book gives essence, and that's why I jump to the definition where under point of order must be used in terms of the prescription. Now it also says if the presiding officer, and I'm saying when you want somebody else, the rules, maybe we must debate it offline. But I'm saying when somebody is on the line and there's no procedural matter infringed, there is no personal reference, that's why it's best to allow the member to make his point, and then you can come in on a point of order. It does not say you cannot. And I've also seen that point of orders, according to me, should be short interventions. But sometimes our points of orders are not to that extent. And that's why I'm saying, allow the member to finish so that we hear what is the member saying, and then you can come. Rightfully, if you support a member, that's where you come in and say, the previous speaker was saying this, I want to supplement or implement with the following code X, Y, Z. So I think I'm of that understanding, unless I'm guided otherwise. Honorable Amundse.
Yes. Why are you still there?
You want to come in?
Yeah, with point of information.
Is it on this point of orders?
I'm raising on the strength of Rule 83(1)(g).
83(1)(g).
Yeah.
People will also make their...
We stand...
Yes.
We stand here
okay.
in accordance with the rules. We don't just shout by saying no, no, no.
Mm.
Yeah. Honorable Speaker, I'm not too sure whether I have a list of candidates for appointment or to debate on insofar as this motion is concerned.
this motion. No. Thank you, thank you.
I need your guidance.
I've lost you there, my brother. Me, I will not be shy away to admit. It's the Queen's language. It was made in England, improved in America,
correct.
Spoiled in Asia, misunderstood in Africa. I'm African.
Correct. I think we are finding one another.
Yeah, I've lost you. Come back.
I have been lost. I've been lost, you know, for the past 40 minutes when the debate has been going on. Because the motion that is before me, Honorable Speaker, or in terms of the order paper, is the debate, you know, a debate to provide directions. Okay? Direction on the ACC.
Correct.
Okay. Direction to provide, a debate to provide direction on the ACC. Okay, and then you have a junction in the form of and, then the appointment of its director and the deputy director general, among others.
You have the floor, Honorable Member.
Yeah. Now, in terms of my interpretations and the construction, so the debate is limited to the directions on the ACC, and then the debate is then on the appointment of the director and the deputy director.
Yeah, please let's listen. Let's listen.
Yes.
Yeah.
So I'm then asking for your guidance, Honorable Deputy Speaker, you know, as to whether it's the manner in which the motion is constructed, or it's us that are misdirecting ourselves in terms of the debate. No.
Yeah.
No, look at the construction.
Are you putting a question to the presiding officer?
No, Speaker, I'm simply saying the motion that is before us in terms of the construction.
Yeah. Okay, Honorable, let me come in.
Yes, please.
Okay, you see, and maybe I must take the example of Honorable Moton when he was explaining Manchester United and Arsenal. Yeah. No, just wait. I'm not choosing a soccer team. I'm saying the presiding officer is more like a referee in the rugby game. Whether it's chula or what, it's a rugby game. And when the two opposing teams scrum, then it's just for the ball. The presiding officer is just to say who's right out of the scrum and who's wrong. So I cannot really sit here and read every intervention of a member. But you are right. This is the debate. To say Africans or honorable members who have contributed, my understanding in terms of the wording is this. You are not on the right track. I think the right track should be this, or you give your guidance together with your team. That is what needs to happen. Not for me to say you are right, you are wrong. That's why I'm not a lecturer. So I'm just a presiding officer. Lecturer is the one who can tell you you are right or you are wrong. Yeah. Okay.
What is it? Yes. Honorable Deputy Speaker, is on the strength of exactly what you have said. That customarily, I do not want to rob anybody of the opportunity to contribute. But I want to be on the same page with everybody, because the manner in which the motion is constructed, my understanding, insofar as the language is concerned, it implies that the debate is on two things. One, on the direction, and two, on the appointment. And the direction does not apply to the appointment if you read.
Okay, let me, no, I think I will give now, it's time. Just sit.
Time for what?
Yeah. The PM. What I will do is, it was Honorable Ihemba that I will ask to postpone the debate for, I don't know, you can depend, but it's a very interesting debate, or tomorrow is question time. But please just postpone, and then we can continue. I think it's Tuesday. You can take Tuesday. 7th. 7th is Tuesday. 7th is Tuesday, ne? Okay, 7th.
Okay. Thank you, Deputy Honorable Speaker. Very interesting the way we are finding each other in this 8th Parliament. Therefore, this debate is very, very important and constructive to our nation building. So I therefore postpone this debate to the 7th of October. Thank you.
Thank you very much. Honorable PM.
Stand adjourned until 14:30 tomorrow, only for, sorry, only for questions.
Okay.
Oh yeah.
Yeah.
Yes.